Hi, good afternoon, everyone. I hope everyone hear me. I'm delighted to connect with all of you, and thanks for your presence in the session today on Digital Personal Data Protection Act. The session will provide an overview of the Act and how it will impact the Global Capability Centers, or as we call it, GCCs. Quick introduction before we start. I'm a partner with GT Bharat and a part of the firm's GCC channel. Just to let you know, guys, GT Bharat has a dedicated sector focus on the GCCs, and we provide bespoke solutions for a variety of requirements. We have been engaging with our clients on several projects, including data protection and security. So I would like to introduce who we have today with us. For the session today, we have Niti Paul. Niti is Regional GPO at Capgemini. She has over 14 years of experience in the area of data protection, intellectual property, company law, and regulatory compliance. She has been advising on matters of misappropriation of confidential business information, has assisted clients in conducting privacy impact assessments and defining risk classification norms and laying down comprehensive GDPR compliance programs. And just to add, Niti is a qualified lawyer and has been a practicing professional as well as an in-house counsel with various organizations and consulting firms. So welcome, Niti.
Thank you, Ruchi.
Our other panelist today is Jaspreet Singh. Jaspreet is a partner with GT Bharat and leads the GCC channel for the firm. He has 20 years of experience in cybersecurity, data privacy, IT strategy, digital transformation, and business continuity planning. Jaspreet has worked extensively with various global capability centers and has advised them in the area of resilience, cybersecurity, data protection, tech audits, and setting up the tech COEs, among others. Welcome, Jaspreet.
Thank you, Ruchi. Hi, Niti.
Great. So before we start the session, I would like to provide some housekeeping announcements. We will start with a brief presentation on the Act, which will be followed by a panel discussion, post which we will be answering the audience questions. Except for our speakers, all the participants will remain on mute throughout the session. So please, there is at the bottom of your screen, you will see a Q&A icon. So please click on that and post your questions. You're most welcome to post your questions during the session or during the Q&A round as well. In case you want a particular panelist to respond, please mention that in your question. And while we'll try and answer all the questions during the session, but in case we are not able to, we will send an email to you and we will reach out to you and respond to those questions. So hopefully we'll be able to kind of address most of your concerns. So without much ado, let's start the session. May I request Jaspreet to please provide us with an overview of that. Over to you, Jaspreet.
Thank you, Ruchi. I hope everybody can see my screen. A very good afternoon. So why are we talking about this landmark bill that has been passed and has become an act in India, right? Is it a new journey now? What happened was in 2012-13, some European ministers' health data got compromised, and then European Union decided that they'll enact GDPR in 2016, which became law in 2018. During the same time in India also, we saw that 2016 to 2019, there were a lot of discussions in the Act. It was tabled, and then finally it became an Act on 11th of August when it was passed by both the houses. The earlier Act was completely scrapped in 2022 August. After 11th of August, it's become an Act, like in the Constitution of India. It applies to everybody in India. I'll quickly talk about some of the salient features of this Act, right? It's only applicable to digital data. If there is any data which is available in physical form and is not digitized, for example, if you walk into any office, right, and you sign on the visitor entry register, If you don't digitize that register, don't scan that register, it's not applicable on that. Uh, it's but it applies to data of Indian citizens, data processed digitally, can be collected both online and offline, right? The law talks about 6-7 key principles. The data should be obtained through a lawful manner, in a fair manner. It should be used only for the purpose of for which the data is collected. If you are taking my age to verify whether I'm a minor or a major, you have to only use that in that conjunction and not use the data for any other means. If it's a multinational company taking my data for processing my invoice, they cannot give it to the marketing department to use it for their F&B business, for example, which leads to data minimization. I'm sure a lot of you would have uh, changed jobs, applied to school, colleges, and you would see that the forms are like 3-4 pages forms. Do the companies really need that data? With this act coming into picture, a lot of organizations, including the GICs, would need to go back to the drawing board and actually see what is the data that they have, what is the data that they need, which would in turn help from a storage limitation. And the most important facet of this bill, and by the way, this bill is for data principles. It's for people like you and me. It's very, very citizen-centric act, right? Uh, Wherein it's the organization's responsibility to put adequate safeguards to safeguard data. It does not talk about what those reasonable safeguards are. And finally, it wants or warrants accountability to be fixed. 3-4 key terms, like in GDPR, data fiduciary, it's the organization that collects data. For example, Grant Thornton or any other organization which is registered in India, any private limited, public limited partnership firm. Principal, data principal is somebody whose data is being collected. I am a data principal. Every citizen whose data is being collected is a data principal. Significant data fiduciary is somebody who's actually processing a data fiduciary who's processing data with 3-4 criteria. If it's a risky data, if the data deals with national security, so on and so forth. What are the 6 key principles on which this act is based? On what is the right is that it is giving to a data principal? A right to access information. I can ask the company what is the data that you have about me, the first right. Second right is right to erasure of data. I can email the organization, right, saying please delete my entire data. How does the organization, number one, decide what is the data that has to be deleted, not deleted? And if yes, how do you delete that data? Very, very important. Right to rectification. Suppose the spelling in my name are wrong or my house address is wrong. I am given an option as a data principal to email the organization or the data fiduciary to change the information. Right to nominate is different. It was not present in GDPR and it's not present in a lot of global laws that we've studied. It talks about if I'm decapacitated or unable to exercise some of these rights, even in case of my death, I can nominate somebody to do this on my behalf. Right to withdraw consent, probably the most important data principle right that we will see will have far-reaching consequences is today if somebody sends me an email, a marketing message, email, WhatsApp, whatever, I can contact that company and say, please stop sending me this information. You have to give the data principal a right to stop giving this. And the last one is the right to grievance redressal. If I'm not happy, I can go to the organization to say there has to be a grievance mechanism to handle these cases. Who will enforce these rights? As per the Act, there is a body, a board, which is called the Data Protection Board of India. The board's formation is in progress. They will enforce all these rights on the data fiduciaries. There are 40 articles in this act, which we will talk about going forward. What has happened since since 11th of August, since the act has been passed, the Constitution of Data Protection Board of India has been formed. It's public news that the rule should come in by about 1st of November. Very, very important question. How much timeline will organizations get to implement this act? As per whatever is available in public domain, organizations will get between 6 months to 12 years, depending upon the type of organization. Tech companies would probably get 6 months. MSMEs, startups, government has hinted that they will get about 2 years to comply with this act. And it will also depend on the type of activity or the type of organization that you are. The more you deal with B2C data, business to consumer data, the more you deal with health sensitive data or data pertaining to national citizens, I think the stricter controls or the stricter timelines will have to follow. Just an illustrative, and a lot of people ask me, Jaspreet, what's the kind of data that will get impacted because of this? We've just took a random sample of 5 departments and just gave an example on what are the data types that every organization, whether it's a mom and pop shop or whether it's a listed company in India, will have this data. So that is the consequence, or that's the quantum of data that any organization has, especially GICs, because they're not only dealing with India data, they're probably looking at global data that would come under the purview of this act. Just a slide on what is the industry doing, working with a lot of organizations in this to help them comply with this. But normally 80% of the organizations are right now looking at 2 fundamental things. One is what is applicable, what's not applicable to me as an organization. What data do I hold? With, for example, the illustration that we showed on the previous slide, what's the data discovery exercise that I need to know? Hand on heart, any person who's attending this webinar, if they can put it in the Q&A and say that they are aware of all the data in their laptop also, that's an impossible ask. Now imagine the plight of a CIO CISO when he has to know the entire length and breadth of data from ingress to egress. What is the data entering the organization to how is it exiting the organization? How do you do that? And on top of that, building a complete data privacy framework for that, and then looking at data transfer restrictions. And then we'll talk about that in subsequent slides. To look at reasonable assurances, which is the security of processing. How do you put enough security controls? Give you a very, very classic, simple example. Look at physical security of a room. You can leave the room unlocked. You can put a physical lock. You can put a biometric lock. You can even put a retina scanner. What determines the value of the lock is what is the data that you're trying to store. So similarly, when you're storing data like passport number, Aadhaar card, medical history, would you put enough controls and put controls around encryption of data? Whereas maybe some other data that you collect, you may not put as stringent controls as that. So how does it apply? Who does it apply to, right? And we thought let's quickly try and put a flowchart in place. And if you see, very simple question: does the company have presence? Is it a registered presence? Means registered office in India and processing digital personal data in India. If the answer is yes, this does apply. But if the company so suppose it does not apply, but the company is based out of somewhere else, but is still giving services to India, to citizens of India, to data principals who are residing in India, are citizens of India, it is applicable to them, right? And there is a clause, and we'll I put an example at the bottom of the slide. So the company, if a EU or a US e-commerce company is providing services to the citizens in India, is delivering the services in India, it becomes applicable to them also. Similarly, what are the exemptions from this, and these are the two sections. The section 16, section 8 and section 16. It says where does it not apply if the processing company has a valid contract with any person outside the territory of India. So it's like a GIC. If there is a GIC of a large company in India and it is still providing goods and services, then all you need to do is put a data protection agreement in place, and then you will be exempt from the chapter 4. So what should GICs look forward to once the act today becomes much more critical, and you would be subject to various provisions of this act? It should look at data processing agreement. It should look at cross-border data transfers. How do you provide notice and consent management is probably going to be a key changer. How do you enable the right of data principles on your website, on your app, on all your critical touch points, and obviously the safeguards, the technical safeguards that we've spoken about. And then GICs is spanning all sectors. It is sector agnostic, whether it is GICs of tech companies, finance, telecom, manufacturing. It's probably one of the leading growth sectors in India today. And what is the impact that it would have on the GCCs? They would need to go back to the drawing board to look at what kind of data do they process, what's the data transfer complexities that they will have to keep in mind. Obviously, all this would lead to compliance costs, right? And then how do you manage those costs would become a huge issue. Taken a couple of examples on, what would GCCs need to keep in mind while transferring data from India to other countries to maybe the headquarters, and what are the considerations that they would need to look at when they're transferring data from headquarters to India, right? So very simple. When it's from India to other countries, government has said when the rules will come in, they will give a list of negative countries. That is the countries where we cannot share data. So number one, we have to see that the country where you're transferring data to should not be in the negative list, right? It should strictly adhere to the data protection agreement DPA that is being signed between that. It will also take into account the sectoral laws. For example, if it's an FS-based GCC or a GIC, it would need to look at compliances of RBI, SEBI, etc. And as I mentioned, there should be a valid DPA or a valid contract, and there have to be enough safeguards possible from a security perspective, so that there is no unauthorized access and there are no breaches in this data. Similarly, when we look at what's the obligation from other countries to India, it should look at the laws within that country. They would have to implement and enforce the same kind of legal, technical, and organizational methods, including cross-border transfers of SPI. It must be carried out only through the applicable regulatory obligations and a valid contract within the territory of that is located for processing of personal data. With this, I pass it back to you, Ruchi. Happy to answer any question.
So I think I just wanted to add a couple of observations. I think that was a great presentation, Jaspreet. And just for the sake of the audience's appreciation, this particular act has been tabled or at least gone through conversations and amendments at least 81 times in the last 6 years. So to demystify and to remove the fear and uncertainty that comes with the act itself in the next 30-40 minutes is an uphill task, but I think Jaspreet has done a fantastic coverage of the act in its all. So just a couple of things I think, and I would like to summarize or break it down to 3 things, and I would like to call it the A, B, and C. So I think with the act, we are seeing a lot of increased accountability. So that's what A stands for. And I mean, the Act very clearly introduces a concept called significant data fiduciaries. Now, what this means is bases the volume of data processing that you're doing and the impact that it's going to have on individuals like you and I, we may fall under a special category of list that the government may notify, and our company, our organization, or any data fiduciary may also be listed as a significant data fiduciary. And once that happens, there are certain over and above or additional obligations that one may have to satisfy. The B really stands for the Data Protection Board of India. I think this is fairly new. We are still awaiting some extensive rules around it. This also increases our obligations every time there is a breach. We have certain tasks where we'll have to notify this particular board of that breach and also notify different individuals who are impacted. And lastly is C, which talks about the concept of consent. I think that's also a sweeping change in the Indian legislation. There is a new terminology known as consent manager. We are yet to receive detailed rules around it. But what's very interesting to note here is that the way the Act is worded is saying that the consent manager will be responsible to individuals like you and me, which says that every time we want to exercise the different rights that Jaspreet was talking about, we can address it to this consent manager who on our behalf will get the resolutions from the various fiduciaries who might be processing our personal data. So all in all, very, very interesting changes, some of which are very new and some of which are also not absolute. None of this is absolute rights. It's all, and India's, if I may, is a bit notorious when it comes to having a dedicated legislation versus sectoral rules. So I think I'll give this back to Ruchi, and we will dive deeper into different questions and analyze how it's actually going to play out.
Thanks, Jaspreet and Niti. That was wonderful presentation and the commentary and an overview. So quickly getting into some of the clarifications, and since we are talking about the GCC specifically, and a lot of the data that we speak of on the privacy side is Jaspreet, you mentioned, is the Indian citizen data. And since the GCCs are more focused on the global operations, could you just elaborate into what provisions of the DPDP impacts most the GCCs? Just speak if you could answer that.
Yeah, perfect. I think a very, very important question, right? I think if you primarily look at the purpose of this act, it is primarily to restrict or to help deal with privacy and personal data of Indian citizens. So the bill actually aims to protect the privacy and personal data of Indian citizens, and it therefore applies to processing of digital personal data, which is both within India and outside the territory of India. This is very important. Personal data of Indian citizens, no matter where they are located geographically. Then it grants rights to individuals like you and me to obtain information about our personal data. How is it being stored? How is it being processed? A summary of data, and with whom is my data being actually shared? So today, if I share my data with somebody, with an organization, I don't know whether it's going to one organization, whether there are 10 organizations in the back end, where as a part of the larger ecosystem, my data is flowing, right? So I think that's a very critical piece that this bill gives a right to an individual to know about it. Then, as we discussed, it also gives a right for me to decide when do I want to get marketing material from a right to consent perspective. I would want to delete some data. It gives me that right, correction and nomination. And most importantly, I think is what Niti mentioned. I think from a regulation perspective, the formation of the Data Protection Board of India will be a very, very key changer, right? If you look at what happened with the Indian Banking Code coming in and then RBI coming into picture to enforce, right? It's very similar to that. Once the Data Protection Board comes into picture, I think we'll see a lot of enforcement of this act. Back to you.
Okay. Thanks. So, out of this, Jaspreet, just again re-emphasizing, where do we see? Because this is good that the citizens have that much of a right, but what should be the GCC considering or considerations? Because they will also have to implement all of these areas. So, what are the most impacted area? For example, you mentioned HR is one because that's where, I mean,
So,
considering there are very 25,000, 30,000 people sitting there, and that's one big area I would presume.
so
Similarly,
every organization, Ruchi, and especially GICs, will need to go back to their drawing board, which includes their global headquarters, and see how is this data flowing within the organization. HR is one touch point, right? But HR would have probably tied up with, say, a hiring agency, a management consulting firm, ABCs of this world. The CV comes in from there. So that's one touch point. It may not directly come to the HR department. It might come to some other leadership department, right? So the word to be noticed here is ingress to egress. All departments, I would need to make a data inventory saying how is the data flowing to my organization, especially GICs, because not only are they dealing with employee information or customer information in India, they would be dealing with a lot of information which is being flown from outside. How do you safeguard that information via contracts, via data processing agreements is going to be the key. And with especially European, uh, also European EU, uh, European Union also being very stringent on laws like GDPR, right? So how do you marry to, will it increase my compliance? Well, we'll discuss all of that going
okay,
forward. Because
okay.
this bill or this act is, a lot of principles are actually taken from, so the way we have accounting principles, globally accepted accounting principles called GAAP, the globally accounting privacy principles, GAPP, are 10 are 10 privacy principles. So GDPR also follows that. Our act also follows that. There are just some nuances which are different between both of these.
So I'd like to just
Great.
add a
Thanks.
couple of observations, and that's again from a very operational standpoint, from my experience as an in-house compliance practitioner. So I think to simplify this is you need to have a robust data protection framework. And what by that we mean, if you look at the more defined ways of frameworks, one of the most mature is the NIST framework. And why I always use that as an example when it comes to data privacy compliances, it says we have a 3-line defense, which says that, your first line of defense are your business stakeholders. Now, why I want to make this point is sometimes in the Indian industry, we may be encountered by, and since we're just beginning to take this journey of compliance because we have a new act now, it could be that, this is, say, the data protection officer's role, or it's just the cybersecurity person's role, or is it the legal team's role? So this is going to be the first debate in any organization. And I would say that we need to have a cross-functional department. And like Jaspreet just mentioned, you have to have an entire data inventory, and this cannot be done standalone just by the DPO. So your business stakeholders who are actually maybe your HR head, the IT head, the different functions within an organization, customer facing, sales, delivery, etc. All of them have to come back to you and say, like, these are all the avenues where data is being collected. This is where all the personal data is being processed. And that exercise might sound easy, but it's quite a cumbersome process. And in the second line of defense is all the data protection specialists who can then sort of analyze the risks and then provide you with recommendations. And that's not all. As the third tier also kicks in is your independent audit. And I think that's specifically called out within the act, which says that, you need to engage with an independent auditor to make sure that all of this is working absolutely fine. So this also would be one of the initial exercises that all companies and organizations processing personal data must take into account.
So
Great.
perfect.
Thanks,
And
Niti.
just a point, since you had about GICs, right? Now imagine this for an Indian organization where 90% of the controls sit somewhere else. Somebody else is in charge of collection of the data, storage of data, and I only have access it through Citrix or some environments, which would be the case in a lot of these, right? but I'm still seeing that information. So how do I put those additional safeguards in when I'm actually not even the primary owner of the data? Is a very compelling proposition, and it's not an easy task. You need to really have a team from every department in the organization to deal with this mandate or this act.
And I think it's what's very key is a division and sharing of responsibility. And I think the ecosystem, when it gets matured, will start. We don't have to wait for a regulatory party to help us proactively tell us to do compliance. But what will happen is your suppliers and your vendors will come to you and ask you, can we have these provisions within the contracts? Or you as data fiduciaries would now have to keep in mind when you're engaging sub-processors, etc., to shift those liabilities via contracts and also conduct your own due diligence. So I think automatically the whole ecosystem with awareness will start moving towards a journey of compliance.
Thanks, Nitin. A related question, since you spoke of the GDPR also in between and some of the other global. Now, since GCCs again come from a global environment, they're already kind of complying to some of these global data protection acts. GDPR being one of the most, few years back that came into the picture. So, are there any differences between the two? So the GCCs who are already complying with GDPR, will they still have to do and re-look at some of the areas, or it is pretty much very overlapping? Any views on that? So Niti, over to you.
Sure. So I think, like Jaspreet mentioned, we emulate a lot of the core principles from the GDPR. I think structurally, we are pretty much aligned when it comes to broadly the principles of transparency, accountability, how we are exercising data principal rights, the increased obligations when it comes to breach notification, etc. I think the two main changes that I would notice from an operational standpoint for a GCC, one would be consent manager. We need to see how that plays out. And I don't want to rely too much on consent within the Indian parlance, because I know currently the focus is a lot on consent, but we forget that there is a whole chunk of lawful basis called as legitimate use cases, which is predefined within the act. And I would encourage and recommend all practitioners to also exercise that list and not rely so much on consent, because it becomes super difficult to manage consent real time, because an individual like us have full authority. In the morning, if I give you consent, by afternoon, I have full authority to withdraw that consent. And as an organization or GCC processing that personal data will have to manage that real time, and it impacts the nature and scope of that particular processing activity. So that's one. And second, I think, which is brand new within our act, is that we have something called as, you can nominate somebody else to exercise your rights on your behalf. Now, this is very broad. It also kicks in when during death and incapacitation, and an individual being incapacitated is a rather broad definition. So I think GCCs will have to prepare themselves to get those nominations in place for their employees or clients, whoever personal data that they're processing, and that readiness is something we'll have to observe. And one third last interesting thing is also individuals have some penalty, or if we frivolously start complaining or we engage. So when GDPR kicked in, I remember 2018 was the time when there were a lot of NGOs who dedicated themselves just to file complaints against bigger organizations, some of them being frivolous just because the penalties were seemingly high. So in that, to address that, the Indian Act also says that if somebody is frivolously or repeatedly making those kind of complaints or requests, a penalty of up to INR 10,000 can be levied on an individual. I think that's also something very different and interesting.
Okay, great. Since we're talking about penalties, that there's a, sorry, go ahead.
Which I think will have a far-bearing impact. One is, again, very fundamental definition of minors. GDPR says minor is anybody 18 or 13 or below. we've still stuck to 18. So if any GIC is working with individuals between 13 and 18, then they have a responsibility of taking the consent from the parents or guardians. So if any GIC is working, for example, on social media analytics, and and why I'm giving this example is because a lot of people in the age group of 14 to 17 have social media accounts, right? If an GIC is working on analytics of those and collect data, then they would need to take permission from the parent guardians of those social media account holders. How they will do that is a question. And the second, probably even more difficult task to accomplish is there's a section on breach notification. So both acts say that if there is a breach, you need to inform the authority. In GDPR cases, European Union. In India, it's the proposed data protection board that will be set up. But it also says that you have a responsibility of informing the data principal. What it means is, God forbid there's a breach in India, a notification will be sent to Data Protection Board of India saying, I'm sorry, I lost this much data, right? But whoever data I have lost, I have a responsibility to informing them also. Now, imagine you getting up in the morning and seeing a message saying, hey, you know what? Your data was breached. Your data was found online because of a data breach in this organization. What kind of panic will it create, and how do you enable this mechanism? Is I don't think so many people would be able to answer that. I think that maybe once the rules come in, we'll get more clarity on how this will be enforced.
Okay. I was saying that since you talk about penalties, somebody has posted a question as to what kind of penalties are there for non-compliance. I think, Jaspreet, there was something which was covered on the slide, or
yeah. So I did not cover that, but the penalties are up to 250 crores. It's not an absolute number. What is the process? At least I can explain how the process works in GDPR. We are yet to get the rules in India. God forbid you have a breach. The Data Protection Board will constitute an organization who will come and do an independent audit. Look at your reasonable security safeguards, saying, do you have enough controls in place to actually safeguard that information? Look at your policy, processes, your technology controls, and then decide what's the penalty amount that will be levied upon an organization. But the current number is 250 crores. Depending upon a couple of provisions, 100. For example, if there is a breach of any data that you're dealing with minors, the penalty is 200 crores. There are various provisions of breach of penalties, but the highest is 250 crores.
okay. So also, Jaspreet and Niti, now the law is applicable to Indian citizens, right? And there could be a lot of NRIs which are not residing in India and residing outside. So which means that by default, a lot of data is being collected overseas, but like as a part of the GCC, because typically the perception is that a lot of the GCCs will be 60-70% managing the foreign national data. But then it's very difficult to bifurcate when you are collecting the data, which is there could be a lot of NRIs sitting there. So in terms of the operationalization of the compliance, what are some of the challenges that you see happening in the GCC, if any, and how does one overcome that? Niti, do you want to go first?
Yeah, that's a very, very interesting question. In fact, when the GDPR was rolled out, and we remember the extraterritorial applicability back then was restricted just to say offering of goods and services. And currently, that's exactly the language that's also being used in the Indian parlance. But funny story. Couple of years down the line, the courts in the UK also started holding within Europe, saying that irrespective of any commercial usage, so which means that irrespective, even if there was no offering of goods and services, but an innocent marketing material that hit your inbox from overseas, just and I could still process your MAC ID, your IP address, and some other location related details because you did visit my website at some point. And then we have the whole game of cookies that happen at the back end. that would also fall within the scope of that extraterritorial applicability. So it's a very interesting case scenario that you're mentioning. And if you ask me, I would be rather overcautious, because this moment has been lived 5 or 6 years ago in another continent, where we would imagine that these mistakes have already happened. So if I were in a place of someone who has to audit a compliance, I would rather also say that the moment we are processing even something not for commercial usage, it would fall under the scope, and that's just being overcautious. And when we talk about organizations complying, it's never like, all boxes are checked and it's done. It's never. Otherwise we would have a certification mechanism for these kind of compliances, but that's never the case. So it's always going to be in the context with a balancing act. So in always, in line with the scope and the impact of processing of personal data. So I think it will always have to have, depending on case to case basis, that we will see whether it's applicable or not. So this is just a roundabout answer to tell you that this will not just, and technologies are so sophisticated today that we can't only say that the name and location, address, and all of that is personally identifiable information. There is a combination of so many data sets happening at the back end, which can help me identify a person. And so any targeting to that person will also fall within the ambit.
So I'd like to, Ruchi, I think you answered the question yourself when you said, if I'm collecting data of two individuals, for example, both of you on the webinar itself, one is an Indian citizen, one is a non-Indian citizen. How in my database, number one, do I make that demarcation? Not only do I do that demarcation, but then how it traverses through the entire organization, whether it goes to sales, marketing, HR, every organization can't have two different processes, right? Saying I will only target Indians staying in this, Indian citizens for this campaign and not target others. I think there will be, as the subsequent rules come in, we'll get more clarity on how will we deal with such ambiguities. But apart from investing a lot of money in technology solutions, I don't think so there is a ready-made answer on how will you distinguish between data of Indian citizens and non-Indian citizens. And number two, if you look at breaches, right, the section on breaches talks about breach of an organization's data. It still does not talk about breach of PII. What if the data that is breached is non-PII data? Will this act then be applicable, not applicable, is something which, only the rules will tell us going forward.
So let me just put one question from my side, and then I'll take up questions. It has been a lot of questions being posted on the chat as well. Now, considering this, and both Niti and Jaspreet, you can answer that. Now, what are some of the key considerations that GCC needs to take to make sure that they are compliant with the Act? And what are the key steps that they can take to kind of for compliance on the Act?
So, Niti, if I can go first, I think it's like going back to grassroots level, Ruchi, if you ask me, right? No organization, especially GCCs, given the maturity of the industry in India, will be at zero, right? And it's not only India who's come up with a data privacy law. There's been GDPR. There's Singapore that has its own law. There's US, for example, state of California has their own law called CCPA. So every organization today would have done some steps from a privacy perspective. So no organization is at zero. So I would suggest organizations should actually start with doing a basic gap assessment, but not only at a policy level. I think most importantly at a technology level, right? Once you've done that, go to each department and understand what is the kind of data that they handle. PII data, personal identifiable information, because that is the backbone of the entire act, right? Once I have done that, then like Niti mentioned a word which was lawful processing. What is the data that I'm collecting? Why am I collecting? What's the need for that data? Draw up a retention schedule. I will give you an example. Today, If I send an email to an organization saying, please delete all my data, that organization can delete some pieces of the data, but things like my salary details, my provident fund details, they have to keep they have to keep that data for 8 years for for regulation purposes, right? So they can't delete that data, but I need to know what is the data that I own, what I can delete, what I can't delete. And on top of that, after I've done this entire data discovery exercise or data handling exercise, then I need to write down policies and procedures. If I have to inform of a breach to the Data Protection Board of India, how will I get to know of the breach? How will I inform? What all information will I include? And finally, put a governance structure in place, which includes representation from the entire department. And whether it's whether the act comes into whether the timeline to comply with this act is 6 months or 2 years. Imagine any organization and imagine the time it would take for them to comply with all of this. One interesting aspect before I give it to Niti. For example, the consent piece. When you collect consent, the act currently says, as per the constitution, you have to make it available in the languages written in constitution. The constitution mentions, I think, 18 languages.
22 languages. Yeah.
So if you have to take your consent, Ruchi, to record this webinar, I have to give you an option in 22 languages. Please tell me, how will you enable it technologically?
Yeah, great. Now that's one thing very different from a GDPR, right? Somebody is asking what are the key differences between the two. I think this is one big difference.
Back to you, Niti.
Niti, anything you want to add?
Yeah. So also a lot of the emphasis stays on the security measures, organization measures, what technical measures. Now, breach traditionally in India, we would have seen, and I don't want to name the cases which we've seen, it's usually massive attacks, okay, by a threat actor. And millions of data of Indian citizens are out there somewhere in the dark web, and it's sold for very minute amounts, right? That is what in the in our traditional parlance we have seen that's what a data breach is. But we forget that alteration of data, decommissioning an IT server incorrectly, that falls within a data breach if it is storing personal data on that particular server. So like Jaspreet mentioned that if someone asks me for data deletion and I go ahead and I delete all the data, I might be in compliance of data privacy, but I'm in non-compliance of the labor law, of the payment regulation, the RBI, social media, intermediary rules. And like I said, there are 100 other sectoral norms that we follow when it comes to, say, insurance providers, payment-related data, etc., which have very specific norms and rules around how we need to retain that data, in what format, etc. So it has to be a risk-based approach, and this is going to be a continuous exercise before, and I think that's one piece of advice I would like to give to all the acting and future DPOs, is it's not really a yes or a no or a DPO approval sort of approach that we must have for any situation. We need to do that balancing act for anything and everything that's prescribed under the act, because it's not absolute. And basis that, we need to take that decision in line with what your business is also proposing. So sometimes you're also seen as, we are not business enabling when we walk into a room and say, well, this is not allowed and, you should take consent. But there are ways and alternate means, etc., which with consultation, you would understand, in the coming years as to how to navigate these different challenges.
Okay. Somebody has asked a question to Jaspreet that what methodologies or frameworks can GICs take to conduct a comprehensive risk assessment that considers local, national and global data protection risk under the DPDPA?
So I think I would advise, today's India, suppose you are a GIC and you serve about 14 odd countries, right? From a global parent company perspective. Today it is DPDPA, there was GDPR, then Singapore, then Oman, for example, a very small country, is coming up with their own act, which is called Oman GDPR. Sri Lanka has passed something called as Sri Lanka GDPR. But the tenets of the privacy acts remain the same. I would I would probably start by doing a risk assessment on something which I call as UPF, Unified Privacy Framework, right? Whether it is breach. So let's put a breach management procedure in place. And if GDPR says 72 hours for that particular set of data, put 72 hours as the compliance need. In India, if the law tomorrow says 8 hours, put 8 hours. But effectively, you'll have to put a breach management procedure in place, and then customize it to few acts. So you should start your risk assessment from by combining all of these into privacy principles, and then going into specific laws, whether it's national or global data protection laws.
Hope that responds to that. Niti, there's a question for you where the act is silent whether a notice needs to be provided if personal data is processed under certain legitimate use. So how should this be interpreted? As a data principle, will I be provided notice if my data is processed under any of the legitimate use?
Yeah, great question. Thank you for that. The Act currently says that only when consent is sought should a notice be provided. And as I would rely on a broader framework, I would suggest that we rely on the principle of data privacy, which says transparency right at the onset, which is like at the conceptualization stage. The moment there is a collection of personal data, say you are registering for this webinar, there is a pop-up, you want to register, you give away your credentials, there's some amount of exchange of personal data. There should be a pop-up button which leads you to a page where you can read a notice which says what personal data you're collecting and what is the purpose, for how long they're going to keep it, to whom all are they going to share. And also one solid recommendation is to not make it very legal, but to keep it super simple, concise, easy to understand, because some of the service providers, as we notice, their privacy policy runs into pages, and we just end up accepting because no one really has the time or the understanding of what is happening with their data. So I think with the new act, we do luckily have these wording prescribed within the act that it should be concise, there should be transparency, and some of the details are absolutely mandated to be provided.
Great. I think that answers the next question. Somebody posted, can you elaborate more on the consent part? What kind of consent will the organization have to take? I think you said that it needs to be concise, comprehensible, understandable, rather than just giving 5 pages, which everybody will say yes, which I think all of us do, even on the cookie side. Nobody cares. We just sign off and then we say, yeah, fine. We will see what happens.
So the idea of consent is very clear. Like Niti said, today if you pick up any terms and conditions, consent would be font 2, 8th, 9th terms of condition, right? We cannot get away with that any longer.
Correct. Okay, somebody has posted that section 10(2)(b) appoint an independent data auditor to carry out data audit. Are there any indications of how long the transition or compliance period could be before this requirement is enforced?
So as per rightly said, section 10(2)(b) is not applicable to everybody. It's only applicable to significant data fiduciaries. There are 6 conditions of whether will you fall in that category, and we'll wait for the rules to say who will become a significant data fiduciary and who will not become a significant data fiduciary. If you fall in the category of significant data fiduciary, then it talks about appointing an independent auditor to do an annual audit. Right now, the frequency is annual, but it depends on when the rules come into picture and from what date, is this required to be compliant. If you look at the Act perspective, post 11th August, if you consider yourself deemed to be an significant data fiduciary, it would be good to start at least documenting some of these policy procedures or doing the gap analysis in place.
I think somebody did ask the question also, if the rules are yet to be out, is the law even applicable right now? So I believe you did mention it is applicable. Okay. Somebody asked, and it's a very interesting question. I think everybody's asking. So, what about the does it apply to one Meta platforms? Also, the opportunities related to emerging technologies like AI or IoT and blockchain, where, as we know, the data gets collected on the go. And how do you think the GICs can harness these technology now, considering that this Data Protection Act has come, where the processing of data is happening here?
Okay, so sure, I can pick this up. So I think, again, excellent question. Timing cannot be better. So I remember a time when we would say that, we would give them our data 10 years ago, 20 years ago. It was maybe filling out on a piece of paper that, we say that this is for our lottery ticket or something. And if I would ask them, imagining that the act was applicable back then, and say that I want this data to be deleted, it would have been deleted in the exact same form. But today, with the kind of sophisticated technologies, it's like that data would have gone through so many phases of changes that I wouldn't even know if that data exists in the form in which I submitted the first time. So, for example, if I gave you an orange, the orange at the end of the process is not an orange. You could have made a juice or a pulp or a squish or a smoothie out of it, and it's impossible for me to segregate and tell you that, yeah, this is what my notice reads and this is how. So one of the most prominent AI-related rules when it comes to privacy is explainability at its core, which means that every AI developer or every AI organization who's using or processing personal data using AI needs to be very transparent in order to say that what is the kind of data that they're collecting. And I know this could also run into a lot of overlapping IP related problems, because at the same time, when you have to explain what your algorithms are doing exactly with the personal data, it could also be your proprietary mechanism of running that AI. But I think one is keeping explainability at its core, and this is fulfilled through transparency. And second is the increased obligations and accountability when it comes to AI. So it will be over and above that the legislation is calling out right now. Unfortunately, there is no mention, but needless to say, there will be very specific rules and guidelines coming out with respect to AI. Jaspreet, I think you wanted to add.
No, I think you've covered it all.
Okay, so I think we can take last couple of questions, because we're already running out of time. Somebody asked that, I think you pretty much, Niti, kind of said that there's a big mind shift, especially with India, because like you mentioned, our data kept free flowing, right? We never bothered, nobody bothers, right? Especially in the financial institution for marketing, and most of the times we don't even know how and who would we spread our contact numbers. We don't even think twice. So I think that
but that's a key aspect of the bill or the act, Ruchi, which clearly says if there is any personal data that I have voluntarily made public, this act does not apply to this. For example,
but then I think that's sorry to speak, but I think that's the trick, right? When I'm giving my data, I'm not necessarily saying it's a public data, right? And I'm not saying
if I'm putting my phone number on LinkedIn.
Not LinkedIn. Suppose right now also, even if the way the backend data receivers, they sell our data. We all know that. We keep getting these phone calls all the time, and we have no idea how do they know it, right? So we know what is happening at the back end. I think that's the mind shift that they are talking about, is that with this law coming in, do you see that now all of these people who are freely selling the data of Indian citizen is going to contain, or is it still think that
it will? See, it's a paradigm shift. If you ask me, it's last 3 years after, I think, fundamental right to privacy. This is probably the most important act that has come in, because it will fundamentally change the way we do business, the way organizations operate, the way GICs operate in India. You have to go back. It's like going back to your drawing board and drawing the naksha of your house all together again, right? To be able to comply to this act. I think that's probably the analogy that I can use.
I think I wanna look at this in a slightly different manner. I think the success of GDPR was really the awareness and the consciousness that individuals exercise towards protecting their rights. Okay,
Right.
in
Right.
India, all you need to do is open a bank account, and I can promise you that your data will be shared with the 50 different verticals of the same bank, and you suddenly become eligible for 50 other services that you never even opted for, right? So with the disclosures, with the obligations of transparency and privacy notice, I think we as individuals whose data is being processed, we need to be more guarded and we need to be more aware and conscious about our rights. Also, another observation is when we do accept the privacy notice, it shouldn't be that, there is no other option or I do not accept. For example, today we only see that, well, here is, this is an acceptance box. You accept it, you get the service. If not, it's a denial of service. I think that's not the way this is supposed to happen. It is supposed to be a freely given consent, which means that I should also be given an option of not consenting or limiting the processing of my data only for purposes like A, B, and C. So that kind of let's say ease of use of service is something that we need to work towards, Ruchi, and I think individuals need to exercise their rights more and more.
No, thanks, Jaspreet and Niti. I think we are 3 minutes over, so we should close this now. Thanks so much, everyone, for your participation. Jaspreet and Niti, it was an excellent, at least I learned a lot today. It is great. Hopefully, as you mentioned, one thing that definitely is going to happen now, like what happened with GDPR, is that people who are becoming more and more aware about their rights, and then they are going to be questioning the people who are just freely selling the data. On the GCC side, yes, I think it is pertinent for them to even go back and see as to if there are any areas which require them to assess the way they are transferring data across regions, also how they are collecting data of the Indian citizen, and how, if there are any additional steps they need to do besides what they're already complying with some of the global compliances. So thanks a lot. So one more thing, I think a lot of people have been asking for, like how they can reach us. So one, everybody, we will be sharing with you the recording and the material of what we have discussed today, and we will also be sharing everybody's contact details on the email. But please, you can reach out to me, Jaspreet or Niti. It's a fairly simple. It's just Preet .singh2 at ind.gt.com or ruchi.sharma1 at ind.gt.com. And we will share all three of our contact details for the further this thing. So thanks a lot. Very interesting session, and thanks for all the questions. I know we have a lot of questions which we haven't answered, but don't worry, we will be sending you emails and responses to all of these questions. All right. Thank you so much, and have a good evening.
Thank you.
Thank you.
Bye.
Bye.
Thank you.